peaceful, and even seems as if he was only persuading people to honor the memory of some people. However, the defendant, in his typical aggressive way of speaking, began issuing threats to those who might want to obey his order, that might not want to obey his order. The people of the Southeast are Nigerians, and I take judicial notice substantially are Christians who go to church, and merchants that are into trade, and their children who were threatened against going to church, their places of business and schools. This cause wonders if this can be said to be agitation for self-agitations. Unequivocally, I say no. The people of the Southeast of Nigeria are entitled to their right to personal liberty, freedom of movement under Section 35 and Section 41 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The said section provides, and I quote, "Every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty, save in the following cases and in accordance with the procedure permitted by law. A. In execution of the sentence and order of court in respect of criminal offence of which he has been found guilty. B. By reason of his failure to comply with the order of court and in order to secure the fulfillment of any obligation imposed upon him by law. C. For the purpose of bringing him before a court in execution of order of court or upon reasonable suspicion of his having committed a criminal offence. D. In the case of a person who has not attained the age of 18 years for the purpose of his education or welfare. E. In the case of persons suffering from infectious or contagious disease, persons of unsound mind, persons addicted to drugs or alcohol, vagrants for those people or purpose of those care or treatment or protection of community. F. For the purpose of preventing the unlawful entry of any person to Nigeria or of affecting the expulsion, extradition, or unlawful removal from Nigeria of any person or the taking of proceedings relating thereto. Provided that a person who is charged with an offence and who has been detained in lawful custody awaiting trial shall not continue to be kept in such detention for a period longer than the maximum period of imprisonment prescribed for him. Section 41 provides, every citizen is entitled to move freely throughout Nigeria, to reside in any part thereof, and no citizen of Nigeria shall be expelled from Nigeria or refuse entry thereby, or exit therefore. They are also entitled, unquote, they are also entitled to their right to freedom of religion as expressed under Section 38 of the Constitution of the Federal Republic of Nigeria. The right to personal liberty, movement, religion are complementary of each other. Court jealously guides these rights, and they are basic rights which denote to them as being human beings. These rights are so fundamental. Kindly see, my Lord Agagu JCA has initiated on this in Okafor versus Lagos State Government and another citation supplied. The people of the Southeast cannot be ordered to sit at home by a person, especially for someone who is not a legally recognized official of the federal government or an official of any of the states. The only person entitled to restrict movement of persons within Nigeria is the President of the Federal Republic of Nigeria under emergency power under Section 305 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The President can order for a coffee area where there is a crisis or natural disaster. The defendant is not the President of the Federal Republic of Nigeria, thus lacks any power to so declare a seat at home in any part of the country. The defendant arrogated to himself power to he lacks, and with the threat of violence ordered the residents of the southeastern states to stay at home or face the consequences of their disobedience. This is an unconstitutional act which is subversive and amounts to nothing more than a terrorist act. It is also a notorious fact that the people of Southeast have been subjected to sit-at-home threats on Mondays for years now. PW4, who stated that he was stationed in the Southeast, especially in Imo State for some years, gave evidence that Monday sit-at-home is a usual occurrence wherein the towns are deserted, even the farmlands. PW4 also gave evidence on the death of one Ahmad Goodluck, a former aide to the former President Goodluck Jonathan, that the said Ahmed Goodluck had been killed by airports meant in pursuant to the order of defendants. Ahmad Goodluck was trying to catch a flight out of Owerri on the 30th day of May 2021 when he ran into a checkpoint by airport and was shot dead. PW4 stated that he was one of those who got to the scene first. It must be noted that 30th of May 2021 was a Sunday, not a Monday, but notwithstanding, it leads to the death of a person trying to move around due to the directive of the defendant as shown in Exhibit PWK. Is a medical report from the Nigerian Police Medical Services, Owerri. The report is dated 18th July 2021 and it states, to whom it may concern, medical report. Late Ahmed Goodluck Ahmed, hospital number. The victim allegedly shot dead by hoodlums suspected to be IPOB/ECN members on 30th October 2021 at about 7 hours along Airport Road, Owerri. Picture of lifeless man seen, body of disease buried, information. The above medical reports, duly signed by the medical practitioner, clearly states the immediate cause of the death of Ahmed Goodluck and links him to the defendant as leader of IPOB and ECN. The action of the defendant cannot be excused under any circumstances. The declaration of a sit-at-home without any constitutional power, especially the accompanied by the threat, is a terrorist act. The defendant did not present any evidence to rebut this case, the case of the prosecution. Consequently, he admits the evidence as presented by the prosecution. The prosecution has successfully proved Kanu beyond reasonable doubt. Consequently, the defendant is hereby convicted of count 2. With respect to count 3, the defendant is charged with professing to be a member and leader of indigenous people of Biafra IPOB, a proscribed organization in which thereby committing an offense contrary to and punishable under Section 16 of the Terrorism Prevention Act 2013. Section 16 of the Terrorism and Prevention Amendment Act provides, and I quote, any person who is a member or professes to be a member of terrorist group commits an offense and is liable on conviction to imprisonment for a time not less than 21 years. The ingredients of the offense from the above provisions are: 1. The defendant must be a person. The defendant must be a member or professes to be a member of a terrorist group. 3. The terrorist group must have been proscribed as at the time the defendant claims or professes membership of such group. As earlier established, defendant is a human being. There is no doubt about that. With respect to second ingredient, prosecution has led evidence showing that the defendant was not just a member, but he was the leader of a terrorist organization known as Indigenous People of Biafra. Indeed, in the broadcast of 16th May 2021, as contained in Exhibit PWW, the defendant, in the beginning of the clip, stated this, and I quote, "My name is Nnamdi Kanu. I am the leader of Indigenous People of Biafra and director of Radio Biafra, Biafra Television. I will remain a loyal servant of the people," unquote. He further stated around 51 minutes mark into the video. If God is on our side, which I know He is, the army of Nigeria will die in Biafra land. Everybody will die. I will be the one leading it. By God's grace, everything called Nigeria will perish in Biafra land. The world must be prepared for what is to come. Unquote. In several other broadcasts, the defendants admitted being the leader of indigenous people of Biafra. There is no fact before this court showing that the defendant is not member and in fact leader of the said group. The defendant from the evidence before this court also possessed power to order the coordinator of IPOP in a broadcast dated 11th May 2021 in Exhibit PWW. The defendants, while commenting on the meeting of Southern governors held in Asaba, stated around 35 minutes to the exhibits. Why plead? And I quote, concerning the lockdown announced yesterday, I urge all people of Biafra and all those in Biafra land to disobey the lockdown order given by the Zoological Republic of Nigeria. The reason is because they want to use the dead of the night to move their fighters into our forest. Because we have defeated their foot soldiers. Mighty Allah, we must resist this stupid lockdown, and it will not hold in Biafra. I am calling on all the coordinators, deputy coordinator of ECN, ESN, and IPOB not to sleep in their houses today, but to look for somewhere else to stay. Because now we are in the trenches. Now you will know what is freedom fighting for. It is not comfortable. It is not rosy. Do not sleep at home. Do not sleep at home. Change your phone and even your phone itself. The defendants no doubt belong to the group and belong to the professing to be a member. He is the leader of the group with the influence of commanding the coordinators of the group. Not only IPOP, but even Eastern Security Network, which is the armed wing of IPOP. In the broadcast of 12th December 2020, the defendant made an announcement in inaugurating the military group known as Eastern Security Network, which is the armed wing of the indigenous people of Biafra. He stated, and I quote, we have cowards, spineland idiots as governors. They have given over our land to the Janjaweed to occupy in perpetuity. This very generation, this very IPOB will not tolerate it. Not now, not tomorrow, not forever. We will rather all perish and die than to allow our land to be taken over by the Janjaweed. This is a warning to all the governors who are conspiring due to one political consideration to give our land to infidel and blood-sucking demons from this time. It cannot happen, not under our watch. We are being told that some of these invaders come from Senegambia, Mali, from Niger Republic, and some from Chad, according to Governor of Katsina State, El-Rufai. Therefore, we are setting up the Eastern Security Networks to combat the excesses of these vagabonds, criminals from crossing the Jail along the same line as Amotekun, the one set up by Mighty Allah. What we are launching before the world today is Eastern Security Network, not a Biafra army, and we will let the world know when the army is to march. But for our present purposes, we are setting it up to defend our land, Biafra against Maronda from the Shahid and the Islam incursion led by terrorists, Fulani, to be precise. In the coming days, you shall see them in their uniform, performing the critical issue of providing security for our land, unquote. The defendants, who was visibly agitated, continue in the broadcast by stating, No governor in the Southeast and South-South have been able to form a security outfit. Therefore, IPOB must defend our land to the very last blood. We shall not stop, not now, not tomorrow, not forever, until our land is get rid of 20 of these Fulani terrorists. In the third video broadcast, there was a side video of the man of the Eastern Security Network, dressed in black with red cap, waving black flag with insignia of Eastern Security Network. This is therefore no doubt that the prosecution has established the second ingredient beyond reasonable doubt. With respect to the third ingredient, the evidence before this court shows that IPOB is a proscribed group. I take judicial notice of under section 122 of the Evidence Act of the order made by my learned brother Nyako J in suit number FAC/ABJ/CS/A71/2017 between Attorney General of the Federation versus Indigenous People of Biafra, today dated 20th September 2017, wherein the activities of Indigenous People of Biafra were prescribed. The said order crystallized into PWJ, which is the Federal Republic of Nigeria Official Gazette number 99 in volume 104, dated 20th September 2017, titled Terrorism Prevention Order number Terrorism Prevention Order of 2017. The Gazette reads, and I quote, Notice is hereby given that by the order of Federal High Court in suit number FAC/ABJ/CS/A71/2017, dated 20th September 2017, as per the schedule to this notice, the activities of Indigenous People of Biafra are declared to be terrorist and illegal in any part of the country, Nigeria, especially in the Southeast, South region of Nigeria, as prescribed pursuant to Section 2 of the Terrorism Prevention Act 2011 as amended. 2. Consequently, the general public is hereby warned that any person or group of persons participating in any manner whatever in any form of activities involving or concerning the prosecution of the collective intention or otherwise of the said group will be violating the provision of the Terrorism Prevention Act 2011 as amended and liable to prosecution. The import of the above is that beginning from the commencement date of 20th September 2017, any person claiming to be a member of IPOB commits a terrorist act. The defendant, by his broadcast of 11th May 2021, 12th December 2020, professed to be a member of proscribed group. Thus, he is in breach of Section 16(1) of the Terrorism Prevention Amendment Act 2013. Consequently, he is hereby convicted of count 3. On count 4 and 5, which are closely related, the defendant is charged with inciting members of the public in Nigeria to hurt and kill Nigeria security personnel and their family members, thereby committing offense under Section 1, Sub 2H of the Terrorism Prevention Amendment Act 2013. The section provides as follows: any person or body corporate who knowingly in or outside Nigeria, direct or indirectly, willingly incites, promises, or induces any other person by any means whatsoever to commit the act of terrorism or any of the offences referred to in the Act commits an offence under the Act and is liable to conviction to maximum of death sentence. The ingredients of the offence which the prosecution must establish beyond reasonable doubt are: 1. The defendant must be person or body corporate. 2. The defendant must have directly or indirectly incite, promise, or induce other person by any means whatsoever to commit the terrorism act. 3. The defendant must have directly or indirectly incited, promised, or induced other person by any means whatsoever to commit the terrorist act willingly or knowingly. The defendants have been established to be a human being by the prosecution. For the second ingredient, it is important to understand what incitement means. According to the Supreme Court per Nikitobi DSC of blessed memory, in CASA and the state citation supplied, hold, and I quote, "An encouragement here means an act of making someone to feel brave or confident enough to do something by giving active approval in support of the crime." Incitement also have the element of encouragement. By incitement, the person is provoked by a strong passion or feeling to commit an offense. The word set is a word of quite a number of synonyms. The two words set on connotes the resemblance of causing to attack or chase, like one may be say the fisherman prepare the bait to set on the fish. It also has the element of antagonism. And instigation, the act of instigating, means something happened by the actions or conduct of a person who is the starter. By the act of instigation, the co-accused is propelled or gingered to commit an offense, unquote. Likewise, the online Oxford Dictionary defines incitement as follows: the action of provoking unlawful behavior, urging someone to behave unlawfully, unquote. The Cambridge Dictionary also defines incitement as follows, and I quote: the act of encouraging someone to do or to feel something unpleasant or violent, unquote. Drawing from the above definitions, the incitements involve provoking or instigating people to do an unlawful act and in their instant terrorist acts. The prosecution has led evidence showing that the defendants made broadcasts inciting public to take up arms against the security personnel in Nigeria to kill them and their family members. The broadcast of 24th day of October 2020, as contained in the PWW, the defendants said, and I quote: "Radio Biafra is now in the hand of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent over 4.8 billion a few days ago to suppress what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that I was joking. They have now come with their clamp down, but they are now going. They are not going to succeed. Radio Biafra belongs to us, but why is it not playing out our program right now?" Unquote. The defendant also stated, "I am telling you people to go to the bush. Whenever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings and they also bleed. Any person with a police uniform or any army in any army uniform is an enemy of the people," unquote. Around 57 minutes to this video marked, the defendant stated, and I quote: "They came to Nnamdi. It is surprised that after British High Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should know, you should not by chalk that the woman is a devil, a big devil. She too will get her comeuppance, unquote. The defendant was referring to Katrina Link, the British High Commissioner at that time. The defendant also said, from what will happen in Aba between today and tomorrow, we tell you how serious we are. Every police officer with uniform, once you come out from your house with police uniform, you are dead man walking, unquote. Callers were calling in from places like Aba, like toll gates and other parts of Lagos, Ibadan, Abuja, Jos, Abia State. Even one Jacob called from Nasarawa State. And the defendants kept giving orders for these callers and other listeners to kill every police and soldiers. The defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get fuel in a bottle and put a rag in it. Then they should set the rag ablaze and hold it at soldiers. In responding to a caller call from Abuja, in that same broadcast of 20th October 2021, the defendant, while inciting his listener to attack the relative or security personnel, stated, and I quote, that every commander they have given his name, find his children. I want to get him in trouble. When they take me to court and ask why I said such thing, I will tell them why. Find the commander. His name is Ifu Umata. Find his children. Find his children. The commander of those on the ground. Find their children. Very, very important. Find their children. Unquote. If defendants went for that, and I quote, start attacking the police, take their guns, use them against them, manufacture motor tours, cocktail, manufacture bombs to bomb them, unquote. The defendant at about 2 hours, 44 minutes, 35 second mark, while concurring with a caller who informed him of the intention of him, other IPOB members, to burn down the Ezima police station, stated, not only one, I want every police station in Aba to be destroyed, completely destroyed, and burn them down. It is an order destroying them completely. Anybody who sees them with police uniform, kill the person. Nigeria wants anarchy. We will give them anarchy, unquote. In another broadcast, the defendant, while responding to a caller, stated this: you people must devise strategy to outfit the army. There are some guns in Edo State right now, as we speak. Use those guns to kill 1 or 2 of their army officers. Take their guns and begin to kill other people as well, because they cannot sustain this protest for 3 weeks. There are guns in Edo State already. Kill the army whenever you see them. Take their guns and kill them, unquote. The incitement of the defendant for the public to kill security personnel is quite clear from his blockers. Not only incitement to kill security officers, the defendant even went as far as inciting the public to destroy all properties of federal government during the NSAS protest of 20th October 2020. The defendant, in another live video dated 20th October 2020, the defendant, while responding to calls from his foot soldier during the NSAS protest, stated, and I quote, if you leave the Janjaweed and their agents the way they operate, if you leave them, believe me, you will suffer. That very hotel must be brought down. I did not say set ablaze. It must be demolished as an example to the rest. If you have not dealt with Tinubu in Lagos, the other will not learn their lesson. Tinubu is an evil man. The hotel referred here to is Oriental Hotel in Lagos, which the defendants allege belong to Tinubu. While responding to a caller, the defendant urged his callers to ambush the security forces during the protest and cut them off. He said, and I quote, "Go to the bush. You need to cut them off from the back, ambush them, take their guns from them and kill them. They are animals and not human beings. They may be wearing uniform like police or soldier, but they are animals. Disarm them and kill them. If you allow them to escape, your life is over, and I want Lagos Airport to be on flame. Breached the perimeter fence and burn down the Lagos Airport. If you have double barrel or pistol, go to the airport and burn it down. Set Muritala Muhammad Airport on fire. Set it ablaze right now. You are dealing with animals. Fulani Janjawi. They do not reason." Unquote. It is important to state that the said hotels and Muritala Muhammad Airport and other property in Lagos, they are not in the north, where it seems to hate with passion. Even its own fellow Igbos people have property in Lagos. With destroying the property is said to be agitation for self-determinations. The threats and destruction which follow were corroborated in Exhibit PWD2, which is a pictorial pictures of the assessment of damage done to the Nigerian police alone in the state of southern states. So many of these police stations and even police officers were killed as a result of the incitement by the defendant. Also, Exhibit PWD2A, which is a compilation of death reports and certificates of death of security officers in the report. The number of police officers who were killed was given as 128. Military officers were 37. Other security officers are 10. Number of police stations attacked were 164. INEC facilities destroyed were 9 in number. This clearly shows the extent of damage caused by the defendants through his inciting statements. Another caller called into the program informing the defendant that he was at Oshodi Apapa Expressway and that they are killing them. The defendant, annoyed by this information, stated for, and I quote, "How many police or army did you kill? I don't want to hear that. They are killing you. How many did you kill?" Unquote. The caller then responded that they have burnt the Orile police stations and Ilasa police station. The defendant then told the caller not to wave the green flag of Nigeria, but a blood-stained flag with the color green, white, red. He further responded to another caller by saying, "What I want them to do is to set ablaze the United building along Marina on fire. Every federal government property in Lagos should be burnt. That is what is going to be signal to the world that people have had enough. I want every federal government building in Lagos to be on fire. Every federal government vehicle or anything belonging to federal government, burn it. Go to the Muritala Muhammad Airport, burn it. How many soldiers do they have? Manufacture your own weapons and unquote." The result of this incitement is the killing of several military officers, police officers, DSS officers. The incitement also led to the destruction of several police stations in Lagos across the southern states of Nigeria. According to PW5, he led a team of officers to investigate the destructions and killing of the security personnel that occurred during the NSAS protest of 20th October 2020, as contained in Exhibit PWD2 and Exhibit PWD2A. The results were quite alarming. The court is mindful not to attribute all the happening during the NSAS protest on the defendant. However, there is no doubt that the incitement by the defendant contributed largely to the killing of security operatives, as well as destruction of public properties. The defendant incited people to destroy properties such as the Lhasa police station, other police stations, and properties of the government. The evidence before this court shows that the said properties were actually destroyed, such as the Lhasa police stations, the High Court of Lagos in Igoshere, as well as PRT buses belonging to Lagos State government in Oyinbo. PW2 also testified that military couples were killed by those incited by the defendants in Olu in Imo State. In addition, PW4 stated that his driver and one of his tactical officers were killed as a result of the incitement. The action of the defendants were clear, as it was aimed to cause anarchy by killing security operatives in Nigeria, which would in turn lead to breakdown of law and order. The defendant had an evil intention to wreak havoc on the people and government of Nigeria. Are all these actions consistent with agitation for self-determination? The answer to this is in negative. His violent outbursts, as well as his instigations of the public to attack and kill security officers in southern Nigeria without provocation, was downright barbaric and without any conscience whatsoever. The defendant did not feel any concern for the family of the officers who were slain. He turned himself to a tyrant who could take life anytime he pleased. Such persons cannot be allowed to remain in society of sane minds. His shocking instigations to kill other human beings was incomprehensible, and this court hereby condemned it. But I must say that the evidence extracted is minute compared to the avalanche of. I must say that evidence extracted in this judgment is minute and very small to the avalanche of evidence and broadcast before this court by the defendant. The defendant made extremely threatening statements, incited people to violence. The prosecution has successfully discharged his burden of proving counts 4 and 5 beyond reasonable doubt. Consequently, the defendant is hereby convicted of the said counts 4 and 5. Now, count 6. For count 6, the defendant is charged with the offense of making a broadcast received and heard in Nigeria within the jurisdiction of this court, in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which he directed members of the indigenous peoples of Biafra, a proscribed organization, to manufacture bombs, thereby committing an offense punishable under Section 1(2)(f) of the Terrorism Prevention Amendment Act 2013. Section 1(2)(f) of the Terrorism Prevention Act 2013 provides: A2. A person or body corporate who knowingly in or outside Nigeria, directly or indirectly, willingly, F. assists, facilitates, organizes, or directs the activities of person, organization engaged in any act of terrorism. The ingredients of the offense expected to be established are: 1. The defendant must be a person or body corporate. 2. The defendant must have assisted, facilitated, organized, or directed the activities of person or organization engaged in terrorist activities. 3. The defendant must have willingly assisted, facilitated, organized, or directed the activities of persons or organizations engaged in terrorist acts. The defendant herein have been established to be a human being. As to the second and third ingredient, the prosecution has led evidence to show that the defendant has directed members of the terrorist organization to build bombs, other explosives in order to attack security operatives. Indeed, in furtherance of its terrorist actions and following the incitement of persons to kill defendants, security operatives, the defendant also directed his members to build explosive devices, particularly motorford cocktail. At about 1 hour, 30 minutes, 36 seconds of the broadcast of 20th October 2020, as contained in Exhibit PWW, the defendant, while responding to a caller about NSAS protest, stated, and I quote, "Now, this night, I want graduates to go to work, graduates of chemical engineering, those who were born as engineers, manufacture any ordnance you can, because they are coming to kill you anyway, regardless of what you do. Go and manufacture any ordnance. I am calling on the youth in the Middle Belt, and I want any bridge that they can use to reinforce to be destroyed. They are going to come from the Middle Belt. This night, we have engineers everywhere, people who are intelligent. Go back now and give us your own version of Molotov cocktail. We must destroy them before they destroy us. Every youth tonight, anybody with a police uniform, anywhere, especially in Aba, in Lagos, once you have police uniform or any army uniform, that person is your enemy. Attack them, because if you don't, they will kill you. If you are a graduate of physics or chemistry, no sleep for you tonight. Go and manufacture something to destroy the police and every army police position starting from this night." Unquote. During the said broadcast, while responding to a caller named Jacob from Nasarawa State, the defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get fuel in a bottle, put a rag in it, that then they should set the rag aflame and hurt it at a soldier. A Molotov cocktail, according to Wikipedia.com, that I accessed at 1 a.m. on 20th November 2025, is a hand-drawn incendiary weapon consisting of a fragile container filled with flammable substances, equipped with a fuse. In use, the fuse attached to the container is lit and the weapon is thrown, scattering on impact. Unquote. The online Britannica dictionary defines Molotov cocktails as a crude bomb, typically consisting of bottle filled with inflammable liquids and a wick that is ignited before throwing. Unquote. Applying the above definition, the directive of the defendant to members of the group to build improvised bombs such as Molotov cocktail is indeed a terrorist act. A Molotov cocktail is capable of causing explosions, damage like any other bombs, which aim is to cause destructions. This directive, like other directive, is a manifestation of anarchy minded of the defendant, which is set out to express through his Biafra radio, which he claimed to be the founder and director. The defendant, through the Radio Biafra platform, carried out so many terrorist attacks, which led to the destruction of lives and property in Nigeria. The defendant is not only confirmed to local terrorists, but I hold without hesitation that he is an international terrorist, flowing from his threat to attack British High Commission and American embassy as well as its incitement against the British High Commissioner to Nigeria at the time, Catherine Lyons, a known woman of peace. In a broadcast of 21st October 2020, the defendant stated thus, and I quote, "Radio Biafra is now in the hand of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent about 4.8 billion a few days ago to suppress what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that it was a joke. They have now come with their clampdown, but they are not going to succeed. Radio Biafra belongs to us, but why is it not playing our program right now?" Unquote. The defendant also stated, "I am telling you people to go to the bush. Wherever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings, and they also bleed. Any person with a police uniform or any army uniform is your enemy." Around 57 minutes mark into that video, the defendant directed his threat at Catherine Lyons, the British High Commissioner. He stated, and I quote, "They came to Tinubu. It is a surprise that after the British Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should not be shocked. The woman is dead, is demon, a big demon. She too will go come repentance." Around 1 hour, 8 minutes, 35 second mark, the defendant also stated, and I quote, the same thing that Britain did to Biafra in what they are doing to us now, media blackout. Do you want the world to report this issue? Take over the British High Commission. That is all. Take over the consulate in Lagos. Take over the one in Abuja. Every newspaper in the world will report it in the morning. If you march on the British High Commission in morning, front pages in the world will carry it, and the world will ask why is British Commission in Abuja and Lagos under occupation by Nigerian youth. Then it is over. I'm giving you a master strategy of how you should be done. In a formation of 3 lines, there is something I want you to do. I'm announcing it on air so you understand. People should go to every weather shop around you. You know those who build bullet-proof door. I don't care how much it costs. We will pay. Everybody who is a welder who builds bulletproof, people should take those doors and put nails in front of them and stand in front of protesters so that bullets cannot go through. Push the door, get the weapons, and deal with them. When you are marching to the British High Commission tomorrow, form 3 lines. They will have the army surrounding them. They will send a cable to London that British High Commission in Lagos is under attack. They will be forced to release it. Then the whole world will know that a revolution is going on. Without that, you cannot succeed. Unquote. Even recently, in this courtroom, on the 7th day of November 2025, when the matter came up before this court, the court wondered the kind of malice and hatred which the defendant had for Britain. I will produce same parts of the proceedings of that day hereunto. Defendant, he says, there are issues at play which my Lord has not able to overcome, which even the prosecution has not even attempted to overcome. My Lord, are you asking me to go into the doors to defend myself on a non-existing law? If you can state that for the record, my Lord, I will be most grateful that you are going to try me or ask me to enter my defense where no law exists. Because if that is the position, my Lord, that means that the outcome of very trial is predetermined. A man of my station and caliber cannot be tried without any valid law. It is impossible, my Lord. I will tell you why. This was the case. This very case is bigger than this court. The case of mine started in 1957 when some brave men and women in this very country dared to ask the British to leave. The funniest thing is that all of them that pioneered that very effort, they all went to jail and were killed. Court, I'm learning this now. Then ask the British to leave. Defendants, yes, in 1957, Dr. Anthony Nao moved a motion at the House in Lagos asking the white men to go and leave us alone. From that day, trouble started. Even before then, the like of Abat Macaulay was jailed, honorable men that fought for the indignity of the black race because they want me convicted. They told me so. Absolutely, my Lord. Absolutely, 100%. They told me. They said, I will come to court to see, to hear your case. When you take your plea, when persecution opens, then their case, when prosecution opens their case, when you start your cross-examination, when they refuse your no-case submission, I am telling you what happened a year and a half ago when you file your no-case submission and is rejected. You will not go into trial. You will be there during the verdict. You will be there during conviction. The court now responded. Let me just clarify this. It is also on record. You said that the British said that 1 year and a half ago that I was not the one presiding here. I want to say this, that I know my brother too, that was ascertain it will not get into that level of having anything to do, anything, because the way you are putting it. I want to say this. I do not have any relationship with the British. I have come here to do justice. I reiterate. Can you commence your defense so that if you commence today, I can extend time for you because your time has ended today. For the U.S. Embassy, it would have been attacked if not for the closure as a result of the protest. The defendant at about 2 hours, 24 minutes, 50 seconds, mark of the video of 24th day of October 2020 broadcast in Exhibit PWW stated, American embassy is shut down. Why won't they shut down? People are protesting. This statement regarding the embassy of United States of America is quite loaded. The statement could mean several things, none which are palatable or peaceful. What exactly does the defendant mean by the American embassy is shut down? Was he trying to attack the embassy if it has not shut down as a result of protest, or incite others to do same as he did in British embassy? The inference to be drawn from the statement is that the defendant meant to do harm to the embassy of the United States by attacking or invading the embassy. Under international law, the premises of an embassy or high commission of a foreign nation is deemed inviolable. That means that even though the land belongs to host country, it cannot invade such premises. See Article 22 of Vienna Convention on Diplomatic Relationship. Article 22 of Vienna Convention on Diplomatic Relations, 1961. It provides thus: the premises of missions shall be inviolable. The agent of the receiving state may not enter them, except with the consent of the head of the mission. 2. The receiving state is under special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage, and to prevent any disturbance of the peace of the mission or impairment of its dignity. 3. The premises of the mission, their furnishings and other properties thereon, and the means of transport of the mission shall be immune from search, requisitions, attachment, or execution, unquote. Thus, from the above, it can be said that the defendant incited for people to invade British High Commission and is threat against British High Commissioner Catherine Lyons and American Embassy is an act of international terrorism. This is the purpose of Section 3 of the Terrorism Prevention Amendment Act 2013, which provides, and I quote, any person who intentionally murder, kidnap, commits other attacks on persons or liberty of an international protected person. B. Carries out violent attack on official premises, private accommodation, or means of transport of an international protected person in a manner likely to endanger his person or liberty. C. Threatening to commit any such attack, commit an offense, and is liable on conviction to life imprisonment. The High Commissioner is an international protected person, being the representative of the British government in Nigeria as well as other staff of High Commission and Embassy of the United States of America, leaving the defendant to continue his terrorist activity who have led to an international incident involving Nigeria and other foreign nations who are good partners with Nigeria. The question to ask again is whether bombing or attacking embassies of high commissions constitutes an action consistent with agitation for self-determination. Again, the answer is no. All these acts goes to show that the criminal tendency of the defendant as well as show concrete proof of his terrorist acts. Therefore, I hold without hesitation that the prosecution as successfully established can cease against the defendant. Consequently, he is hereby convicted of count 6 of the charge. With respect to count 7 of the charge, the defendant is charged with importing into Nigeria and keeping in Ubuluzo in Ihiala, local government of Anambra State, within jurisdiction of this honorable court, a radio transmitter known as Tram 50 concealed in a container of used household items which he declared as used household items, thereby committing an offense contrary to Section 47 2A of Custom and Excise Management Act Cap C45 Laws of the Federation of Nigeria 2004. The dispute as to which law provides for the offense in count 7 has been conclusively decided by the Supreme Court in case of Federal Republic of Nigeria versus Kanu Supra, where my Lord M.L. Garba, JSC, while reading the lead judgment, heard, and I quote, a calm reading of the details of the facts stated as constituting the offense mentioned or named therein would clearly and undoubtedly reveal that it deals with the offense punishable under the provision of Section 47(2)(a) of the Custom, Excise and Management Act, Cap C45, Laws of Federation of Nigeria 2004, which provides as follows: 47(2). If a person A imports or causes to be imported any goods concealed in a container holding goods of different descriptions, or he shall be sentenced to imprisonment for 5 years without the option of fine. It follows in the above circumstances that the mention of the Criminal Code Act as being Chapter C45 or Chapter C45 in Laws of Federation of Nigeria 2004 is a mere mistake in place of correct law. The Customs and Excise Management Act, under which the facts alleged to constitute an offence in Count 15, is punished and punishable. The offence in Count 15 is consequently recognizable and grounded in an extant existing law in Nigeria in which it was defined and described, unquote. Thus, the court will follow the decision of the Supreme Court and decide Count 7 based on Section 47 of the Custom and Excise Management Act. The ingredients of the offence are: the defendant must have imported or caused to be imported goods concealed in a container. 2. The imported concealed goods must have been of a different descriptions. The evidence led by the prosecution through PW4 is that the defendant imported into Nigeria a radio transmitter known as Tram 550L concealed in container which contained used household items which he described as such. PW4 stated that indeed the Department of State Service had tracked the transmitter of Radio Biafra to a compound in Umuluzino in Ihiala, local government of Anambra State, belonging to one Benjamin Madubulu. The officer secured a search warrant, Exhibit PWT, and proceeded to the compound where they recovered the container. Prior to going to the scene, PW4 testified that he watched a video of the defendant inspecting the container and the transmitter with Benjamin Modubugu. The court visited where the container was kept in the custody of the DSS, and same was admitted in evidence in the presence of the defendant as Exhibit PWY, and he did not object to same. The container itself contains several household items which appear to be covered for the transmitter concealed in it. The prosecution has led evidence to show that the transmitter was smuggled into the country without same being declared to custom. That the cover of the household item was used to disguise its true content. The surrounding facts also show that the purpose for which the defendant intended to use the transmitter was to broadcast program on Radio Biafra, and this makes it concealed the transmitter. There is also no evidence that Radio Biafra is registered with the Nigeria Broadcasting Commission, as stated by PW4. Thus, it is safe to conclude that the concealment of transmitter is in furtherance of the illegal operation of Radio Biafra by the defendant. The defendant, as a consequence of resting his case on the prosecution, did not call any witness to report the evidence of the prosecution, neither did he lead any evidence to counter the evidence of the prosecution. There is no evidence before this court stating the transmitter was lawfully imported into Nigeria. The defendant had the duty to present evidence and failed to report the allegation made against him, but he failed and deliberately refused to do so. The court is therefore bound to believe the evidence of the prosecution. Consequently, the court hereby convicts the defendant of count 7 of the charge. I must say here that defendants have always claimed to be a freedom fighter, seeking justice for his people. Indeed, this is known in law as the right to self-determination. The right to self-determination is a political right recognized in several international instruments. Article 1 of the International Convention on Civil and Political Rights, 1966, provides, and I quote, "All people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural developments." Unquote. The right to self-determination also entails the right of a group of people to form their political entity or their own government. Article 20 of the African Charter on Women and People's Rights also provides, and I quote, "All people shall have the right to existence. They shall have the unquestionable and inalienable right to self-determination. They shall freely determine their political status and shall pursue their economic and social development according to the policy they have freely chosen." 2. Colonized or oppressed people shall have the right to free themselves from the bond of domination by resorting to any means recognized by the international community. 3. All people shall have the right to the assistance of the state parties to the present charter in their liberation struggle against foreign domination, be it political, economic, or cultural. Unquote. Nigeria has domesticated the African Charter, which is known as the African Charter on Women and People's Rights, Ratification and Enforcement Rights, which means the provisions of the Charter are enforceable in Nigeria, provided they do not conflict with the clear provision of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 2(1) of the Constitution of the Federal Republic of Nigeria 1999 as amended makes it clear that Nigeria is an indivisible state, which means there is no room for division. The said section provides, and I quote, "Nigeria is one indivisible, indissoluble sovereign state to be known by the name Federal Republic of Nigeria." Unquote. This means that anyone agitating for a breakup of the Federation of Nigeria is going against the Constitution. However, any person agitating for self-determination can do so through the National Assembly seeking for amendments of the Constitution regarding the indivisibility of Nigeria and to reflect the recognition of the agitating state. It is after this that the procedure can be said to be completed, but not excluding a referendum. Any self-determination not done in accordance with the Constitution and laws of the country will be illegal. The defendant is not only agitating for secession of the state of the Southeast, South, and some Middle Belt states. He is doing so using terrorism as a weapon. Terrorism has become a monster in the world today, and several groups have continued to use this weapon to form separate governments. In Nigeria, groups like Boko Haram, Lakurawa, IPOP have in recent years troubled Nigeria with terrorist activities. This terror group, by their activities, has denied innocent people the enjoyment of their fundamental rights. The action of the defendant and his terrorist organization have led to the bloodshed of innocent citizens, as well as security personnel who were going about their legitimate duty. His incitement through the broadcast on Radio Biafra as well as the social media platform of the group has led to the destruction of lives and property, as well as
people of the Federal Republic of Nigeria had brought Nnamdi Kanu before this court for acts of terrorism. And Lord, in the last few weeks or last few days, Nigeria has been a season of victims of terrorism, But my Lord, this afternoon, this Honorable Court delivered its judgment in which the convict Nnamdi Kanu was found guilty and convicted of offences under Terrorism Prevention and Prohibition Act. He has accordingly been convicted and it is now to be sentenced. My Lord, the prosecutor has a duty to invite your Lordship's attention to a few points that will guide your Lordship in the sentencing. My Lord, this court has again affirmed the long-standing principle that whenever Nigeria as a nation country, guided by the wisdom, courage, and integrity of judges who serve within that arm of government. Terrorism, my Lord, remains one of the greatest threats to humanity. It is among the most devastating of atrocities in human history. As the leader of the proscribed indigenous people of Biafra, the convict, through his broadcast on Radio Biafra and through the group Armed Wing, the Eastern Security Network in Nigeria, and took active steps to destabilize the country. By the conviction of Nnamdi Kanu for acts of terrorism, it is clear that justice has been served to the thousands of innocent Nigerians who lost their lives as a result of the inciting broadcast and violent activities of the Eastern Security Network. Their blood of those who have died cries to heaven, and God in his mercy has given them justice. Justice has honored their cry. The families of more than 75 security officers who were murdered in the service of their fatherland will now find some comfort in this conviction. Those whose relatives were brutally killed and buried with equal soul of the order of the convict here have not died in vain, because justice has been done. And Lord, the record before this court are replete with the losses suffered by citizens of Nigeria residing in the interstates of the Federation. Citizens who, through no fault of their own, were forced to live in fear, had their businesses destroyed, and were reduced to paupers as a result of sits at home orders issued by the convicts and violently enforced by the commanders of the ESN. Justice has today set them free from oppression and economic strangulation caused by the terrorist activities of the convict. The convict now knows that the law is greater than any individual. Therefore, justice has been done to him too. And that Nigeria has both the power and the capacity to punish anyone who does deliberate, reckless act of terrorism, seeks to divide the country by attempting to create the so-called Republic of Biafra by force out of the Federal Republic of Nigeria. My Lord, consequent upon the conviction, as nothing further remains but the lawful imposition of sentence. The punishment prescribed for the offences in counts 1, 2, 4, 5, and 6 is death penalty. Pursuant to Section 1(2)(h) of the Terrorism Prevention Amendment Act 2013, my Lord, with all sense of humility, I say, sir, as a prosecutor, that this court has no discretion in that regard, and that the only sentence that your Lordship will impose for counts 1, 2, 4, 5, and 6 is death sentence. This court has the power to do so, and with respect must do so. The language of the act is clear, and the court is urged to apply it strictly without deviation. For the offense under count 3 relating to membership of IPOB, a proscribed terrorist organization, the punishment is imprisonment for a term of not less than 20 years, in accordance with Section 16.3 of the Terrorism Prevention Amendment Act 2013. We urge your Lordship, in accordance with death sentence, also pronounce and impose a sentence as prescribed by law, having found him guilty and convicted. For the offense under count 7, the punishment is 5 years imprisonment without the option of a fine, pursuant to Section 46 and 47 of the Custom and Excise Management Act, Cap C for the purpose of federation. In sentencing, this honorable court is obliged to consider the nature and gravity of the acts of terrorism committed by the convict. It was against the acts of terrorism were against innocent Nigerians who reside in the southeastern states. It is also a terrorism act against Nigeria, whereby nobody felt safe and secure in Nigeria having regards to the activities of IPOB and ESN. The court is also note that the country has shown neither remorse nor penitence for the innocent Nigerians who died as a result of his directives and incitements. He has demonstrated no respect for the administration of justice. His conduct, even within the court, has been marked by arrogance and a heart far removed from humility. When he was going out, he looked at me and said, God will bless me. He won't say God will punish me. He said God will bless me. And I say amen. Because I'm a blessed man. It is not he, the convict, who can now put a curse on me. He cannot do that. So in any event, my Lord, I'm not being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitude. The court is further urged to take judicial notice of the fact that the convict established radio browser, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my Lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications, live broadcasts, and social media communications constitute act of incitement, encouragement, and provocation of terrorism as defined under the Act. In view of the position, my Lord, that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in the southeastern state of Nigeria, including Lagos, would not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. They are amplified and resulted in a coordinated transnational militarism or militarization of violence and destruction of public property across several states of Nigeria. The court has both the power and the duty to restrict further access to digital media through which the offences were committed by making orders that prevent the commission of similar or related offenses, including forfeiture, confiscation, or restrictions of the means used to commit the act of terrorism. As a form of preventive control, the prosecution pressed this honorable court to impose restrictions on the convict's access to digital devices, online accounts, or internet facilities. In other words, my Lord, anywhere he may be kept until his execution in obedience to the sentencing, if he has access to these devices, and they are cheap and easy and available everywhere in Nigeria, there will continue to be broadcast. Maybe he will claim he was not the one. At the moment, if you open to YouTube, you see a lot of rascals talking about the proceedings of his court, trying to twist and mislead and mislead the people with what happened in court. So we're asking that your Lordship should restrict him from having access to these devices. This honorable court, my Lord, has the statutory power to prevent convicts from further committing offences by making orders for the forfeiture, confiscation, and restriction by any means used for communication. We therefore pray that the court to order the forfeiture of all the broadcasting equipment, digital devices, and all the electronic materials seized from the convict and currently in the custody of the Department of State Security State Service. In particular, the radio transmitter Trans-50L, unlawfully imported into the country, should be forfeited to the federal government of Nigeria. My Lord, we want to say, sir, with all respect, that it might be argued that access within the constitutional rights, but it's not absolute. So therefore, sir, if your lordship want to order his restriction, your lordship may give him the right to acquire any, but with the permission, with the authority of National Security Advisor and the Controller General of the correctional facility that he may be put. Therefore, my Lord, it's not an absolute or free right for him to begin to acquire those digital devices that may encourage him to reenact or to begin to commit the same or similar offense under his right to freedom of speech. So we are saying, my Lord, that your Lordship should restrict it. My Lord, considering that the company has to be in a custodial facility, we are asking your Lordship to direct that for the safety of the convict, for his safety, for his security, and for the protection of his life until your sentence or is executed, I respectfully, sir, as prosecutor, plead with your Lordship to direct that he be kept in the safest custodial center anywhere in Nigeria, because his safety is very important. Your Lordship need to take judicial notice of what happened when Simon Epa was sentenced in Finland. There were lots of talks and talks. The convict has enemies. He has friends. But no one can say the volume or the number of his enemies who may want to eliminate him. So we are asking now that your Lordship order the government of the Federal Republic of Nigeria to keep him in the safest custodial center anywhere in Nigeria. You know, and if I may say with all sincerity, I am not too shocked that Kuje, where there have been jailbreaks, will be the ideal place. So I'm urging your Lordship with all sense of responsibility to preserve his life until he answers his sentence. So I thank your Lordship and I pray that the incidents of terrorism will cease from Nigeria, from north to east, to northwest, to north central, and as we see, may God spare Nigeria of disintegration. Now, I want to thank you. I want to appreciate you on behalf of my colleague, Adebayo Ojo, and Suraj Saida. We are grateful to your Lordship, a well-researched, a well-reasoned, and a courageous judgment. Thank you, my Lord.
There is no doubt that the convict has waived his right to be present through its unruly attitude, its habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal, through his person. Since his consultant is here, and the offense has to do with death sentence, I will call his consultant, that was his lawyer before he converted him to consultant, if he has any allocutors to make on his behalf. Mr. Jimako, do you have any allocutors to make on his behalf?
My Lord, being an official in this temple of justice, and not being properly dressed, and not being his counsel of record, I will yield this very task to Honorable Obina Agocha, who is better qualified than me being the member of House of Representatives who represents Nnamdi Kanu.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors. Allocutors is what will mitigate the sentence. Is our brother. Let us hear you. You tell us your name. You can't, because of your rude behavior, deprive him of allocutors. Can I hear from you?
Thank you, my Lord. My name is Right Honorable Obi Agocha. I represent the good people of Iguano, Umaya North, and Umaya South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing solidarity with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, the Lord is my brother. He's my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. The Lord, I plead for mercy, plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it is being done to Nnamdi Kanu There are other people out there also doing more worse than him.
Please,
Sorry, sir.
I ask for a locutor.
Yes, sir.
Please, don't
So, I apologize, sir. So, I want the court to take judicial notice of that this trial has gone on for almost 10 years. Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for the Lord to show mercy, to temper justice with mercy. And as we move forward, we shall be great for our country. Thank you very much for the opportunity. I'm a friend of the court. I will come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4 for the sentencing. I will rise and come back.
Thank you. Well, he's coming on for another matter before that, like maybe you pause your camera before when we are ready for.
Okay, let me.
He's coming back. Sorry, for that matter, coming back in the next 10 minutes to continue. Okay?